This is actually a bill which is complementary to, or will be passed as a complement to, the Road Traffic Amendment Act and its subsequent amendments. And it will also support matters set out in the regulations which we have also just passed. Before I start, I just want to draw Senators' attention to the list of amendments which have been circulated. There have been a few amendments proposed as a result of the review in between the lower house and the upper house. Some address the matter of fines, levels of fines that have been passed in the lower house and which we had agreed with the minister needed to be adjusted. One is a technical matter regarding the manner of service, so just ensuring that all manner of service of documents, of notices and tickets in particular, that they can be effected by different means. The definition for emergency road license is being amended, and it is also proposed to clarify the fit and proper element, which is also provided for in Clause 3. So while the pages may appear lengthy, they are not unduly complicated, and they have also been circulated in soft copy and shared, or previously shared with Senator Morris, although he is not present. Mr. President, the Transport Authority was established by Section 3 of the Transport Authority Act of 1987 to manage and regulate the public transportation system in Jamaica. Members would be aware that the authority is charged with the responsibility for the licensing of all public passenger and commercial vehicles and the regulating and the monitoring of such vehicles island-wide. The authority also conducts other activities that may be conducive to an efficient public passenger transport system. The most familiar function we submit is the granting of licenses to thousands of licenses island-wide to public passenger and commercial carriers. The types of vehicles which exist in this realm are route taxis, hackney carriages, rural stage carriages, contract carriages, and express carriages. For the transportation of goods, there are private carriers carrying goods connected with the owner's business, and there are public carriers which operate for hire and reward. Of course, the authority also ensures compliance with the terms of these licenses and the operation of public transport vehicles for good order on our roads. Enforcement is carried out mainly in conjunction with the Jamaica Constabulary Forces Traffic Department. Mr. President, members would also be aware that the Transport Authority also plays an essential role in the protection of the rights of commuters, including by ensuring that public passenger vehicles, PPVs, charge the approved fares. Time and again, the authority has had to step in where operators overcharge passengers, including children. Mr. President, all these powers are derived from Section 4 of the Act, which centralizes the powers formally granted to the licensing authorities under the Road Traffic Act, the Public Passenger Transport KMTR Board of Control, constituted under the Public Passenger Transport KMTR Act, and the Public Passenger Transport Rural Area Board of Control, constituted under the Public Passenger Transport Rural Act. So this bill before us consolidates a lot of previously existing legislation and puts them together in a cohesive manner. So the bill before us, and just to expressly state that for the record, that it provides for the incorporation of the relevant provisions of the Public Passenger Transport KMTR Act 1947 and the Public Passenger Transport Rural Area Act 1970, and thereafter it will also provide for the repeal of these two acts. Mr. President, this bill also incorporates sections 61 to 89 of the RTA 1938. In particular, it incorporates Part 3, regulation of PPVs and road licenses, and Part 4, regulation of commercial motor cars, with some modifications. The modifications made are in order to address duplications, ensure cohesiveness, and appropriately empower the Transport Authority to execute its responsibilities. They are responsive to current trends in the public transport sector and will strengthen the existing administrative framework. They will also address the matter of indiscipline in the public passenger transport sector by, among other measures, increasing penalties for infractions. Mr. President, the provisions in the bill before us are grouped into 6 parts, each containing provisions for the better administration of this sector. There are also 5 schedules which provide implementation details. Part 1 introduces the bill and states the citation, of course, that is Transport Authority Amendment Act 2022. Part 2 addresses the proposed amendments to the Act, including revised definitions of some key terms and these provisions covering the respective PPT Acts and the RTA, as well as the duties and powers of Transport Authority inspectors and police, forfeiture and sale of seized vehicles, legal professional privilege, offences of public passengers, and protection of officers of the authority. Members may have noted the importance, of course, of the RTA, which is to be brought into force shortly. That is RTA 2018. Several words contained in this bill, are assigned their meanings under the RTA, including Certificate of Fitness, Motor Vehicle, Commercial Motor Vehicle, Island Traffic Authority, and even the simple term road. So again, as I started indicating that this bill is complementary, this is one of the ways in which it is such. Part 2 also elaborates on the functions of the authority. In addition to the granting of licenses and the conduct of inspections for compliance with same, the authority is also required, among other duties, to maintain registers of the motor vehicles licensed, the owners of such vehicles, as well as the licensed drivers and conductors in relation thereto, to develop and implement plans, standards, and other measures for the improvement of public passenger transportation and commercial carriage, to conduct public education for stakeholders, and to construct and manage facilities necessary for the provision of or related to public transport services. Clause 9 of the bill will insert a new section 13 in the Act, which empowers an inspector or a constable to, among other actions, stop and inspect at any time any motor vehicle which he or she reasonably suspects is operating as a PPV or commercial carrier contrary to the provisions of this Act. And in respect of such vehicle, to take a statement from a passenger in that vehicle, to carry out an inspection of the driver and conductor of the PPV or the driver of the commercial carrier and their license, and to give directions to passengers, owners, and drivers of a PPV and commercial carriers to ensure the orderly, safe, and efficient operation of public passenger transport and commercial carriage in any area. Of course, the bill also provides for an inspector or a constable to seize a vehicle and provides for its handling in such circumstances. Mr. President, the amendments in Part 2 of this bill seek to protect the stakeholders in the system. Clause 12 seeks to provide that anyone who, while boarding, on board, or disembarking a public passenger vehicle, commits an offence by A, threatening with violence a driver, conductor, or passenger of that PPV, or does an act which endangers or is likely to endanger a driver, conductor, or passenger of a public passenger vehicle, and among other offences, it will also be punishable to willfully interfere with or hinder the performance of the driver, conductor of a public passenger vehicle while the vehicle is in use, providing public transportation service, or to willfully interfere with a passenger, or to willfully hinder or obstruct a person boarding or disembarking from a PPV. So this is to protect persons providing transportation service as well as persons using transportation services. Part 3 includes a new section called road licenses, and it's anticipated to improve the process of obtaining and renewing road license. Licenses will be issued for 1 year or 4 years, and dates of expiry will be changed to, in the case of an individual, on the birthday of the holder of the license, while in the case of the company, on the anniversary date of its incorporation. The rationale for the amendments are to alleviate administrative burdens and to allow for the 4-year public passenger license holders to be able to better negotiate loans with financial institutions. Of course, we note that the Act does provide for revocation of license in respect of breach, but there is an opportunity to have a smooth system where you are able to procure a 4-year public passenger license. Conductor's licenses and badges are also prescribed in this section. A conductor must attain the age of 18 years, be a fit and proper person, and fulfill such other conditions on conduct as may be prescribed. Just to note that in respect of the fit and proper for the conductor, this is not the usual provision regarding being an undischarged bankrupt or being convicted of any, financial offense. It speaks to their physical ability to do the role of a conductor, to perform the role of a conductor, and relates to the circumstances, any circumstances that are likely to lead to improper conduct in the provision of public transportation services. So in the regulations, they will provide for the requirement for a police record. Again, for the safety of passengers, we know that far too many, especially young girls, have been at risk in the public transportation system, and there therefore has to be greater focus on how it is we manage the safety of that system. And part of that will be knowing and understanding the antecedents of persons who provide services within the public transportation system. Part 4 of the bill seeks to provide for the issuance of exclusive licenses and market service licenses. So of note, except in certain circumstances, when traveling in a vehicle operating under a market service license, a passenger shall only be entitled to carry, without the payment of any additional fare, personal luggage and small parcels which may be conveniently stowed without discomfort to other passengers. So it's different from a commercial purpose. Part 5 addresses the commercial carriers and the applicable licenses, which will be in one of two classes, either one, a carrier's hireage license for the purpose of hire or reward, or two, a carrier's non-hireage license for or in connection with any trade or business. The bill seeks to establish an offense where a person uses, causes, or permits a commercial motor vehicle on the road for carriage of goods, for hire or reward, or in connection with trade or business, except under a carrier's license. And provision is therefore made for application for such a license, which again can have a duration of 1 or 4 years, which shall expire either on the birthday of the individual who holds the license or the anniversary date of the company's incorporation where it is held by a company. And it shall be a condition of every carrier's license, A, that the commercial motor vehicle operating under a carrier's license is not simultaneously being used to carry passengers for hire or reward, and B, that the commercial carrier is maintained in a fit and serviceable condition. C, also, that any provisions, whether contained in this Act or the Road Traffic Act, with respect to limits of speed and weight, laden and unladen, and the loading of goods on the vehicle are complied with in relation to the commercial carrier. Part 5 also seeks to provide for the suspension, revocation, and return of licenses. Mr. President, Part 6 seeks to provide for the establishment of a public transport appeal tribunal to hear appeals of persons who may be aggrieved by decisions of the authority or any agent thereof, A, by refusing to grant or renew an authorization or a license, B, by a revocation or suspension, and C, by any condition imposed or the variation of conditions imposed in respect of a license or authorization, and finally, by any direction given under Section 15U. Part 6 also seeks to provide for the making of an application to the Supreme Court for a declaration where same is allowed under an exclusive license. Mr. President, a fixed penalty scheme has been introduced, itemizing the offences and penalties in respect of which liability may be discharged on payment of a fixed penalty, so that tickets can be issued to offenders instead of bringing all matters before the courts. All the fixed penalties have been reviewed and the sums increased. Part 1 of the new 4th schedule sets out the offences in relation to which liability may be discharged on payment of a fixed penalty, that is, payment to the collector of taxes, at any time before the final adjudication of the case, and such payment may be effected electronically. Part 2 of the 4th schedule sets out the offences in relation to which liability cannot be discharged on payment of a fixed penalty. These are the offences for which a fixed penalty is not appropriate, such as impersonation of an inspector, or assaulting, hindering, or resisting an inspector in the lawful carrying out of his or her duties. Mr. President, further amendments have been made to the bill as listed and as are presented in the note today. I've briefly described most of them, and I imagine that in committee we can perhaps look at the penalties more closely where persons have issues that they would wish to bring to note. But I just wish to confirm that one of the adjustments that will be made by us here today is to reduce the fine that had been put forward for calumnious language, use of calumnious language towards an inspector, and it's improper. To reduce it from 500,000 and 6 months to 100,000 and 30 days. So that is being provided for, and there are just a few others which have been changed from 500,000 to 250,000 and 500,000 to 100,000 in other instances. And just to note that now the fine for that offence is 50,000 under the current law, but it also provides for 3 months in lieu of payment of the fine. That has been reduced to 30 days. Mr. President, I would simply note that, again, this is a complementary provision. It is crucial to providing effective and efficient monitoring and regulatory services to facilitate a people-centered, safe, orderly, and reliable public passenger transport system. It is anticipated that the measures that are provided for here in these amendments will improve the day-to-day running of the road network, and in particular the public transportation sector, that it will allow for a more pleasant, productive and efficient working and travelling environment for all stakeholders. And it is in this context that I submit the Transport Authority Amendment Act 2022 for the consideration and approval of this Honourable Senate. May it please you, Mr. President.
Thank you, Minister. Senator Crawford.
Thank you, Mr. President. I only have two comments. The first is, for the second time I hear about the requirement of a police record in the previous bill and in this bill. However, in both bills, in particular this one, it doesn't tell you what offences are a basis of disqualification. So is it all offences? Is it once you have a record? It hasn't defined that if you were charged for A, B, or C, this is a basis of disqualification. So, well, we just finished our regs. And I'm saying it's the second time. We finished our regs previously, which did not stipulate the offenses that you're seeking to analyze by asking for a report. So I am concerned about that. I'm not sure if the word calumnious, is that it? Right, if that is the one used in the document, but a quick Google said that it is false, defamatory, or untruthful. It didn't suggest that it was a quote-unquote curse word. And I'm happy because, I mean, a curse word should not. I mean, if you resist or if you physically harass, but what we're going to define the curse words? Jamaican people like to call people particular types of names in anger. Is that a curse word? Or is only the ones where we know with the clots? I mean, it's just ridiculous. And then a fine of 100,000 coming from 500, but it just don't make no sense. If a person in anger speak, it's different than if a person in anger harass. the person who is given the duty by government to implement. So I am extremely concerned that, one, we don't have an outline of what we are seeking to disqualify on, and by extension, a man just draw from him wins and fancy based on how he feels, who qualifies and who disqualify for a spliff. They can't be a taxi operator or whatever. And again, we also have to be very careful of how we just throw things out there. Yes, we have a problem with some of our women being, and some of, generally with crimes being against women, and we have had occasions of that being in a transportation vehicle. Is there anything to suggest that those people have a record? Is there anything to suggest that those people in the main are second offenders? There's nothing to suggest that. So to throw that out there, these people who have paid their debt to society for having done whatever, be careful that our laws take away every single opportunity for them to be living a legal life. That our laws now, because it would be reasonable for me to replicate that at my factory, and for Don to replicate that as well at his factory, because whatever concern that you have, especially, or a hotel, to replicate that at his property, whatever concern you have that says a man have to provide a police record and don't define what it is that disqualifies him, is of great concern to me. So I'm concerned about that. And if it is deemed necessary to ask for the record, I think it is also necessary to state what the offenses are that disqualifies the individual. And I believe it is not necessary to have either curse words or defamatory words, because there are additional laws, other laws that exist that actually already deals with that. So I see no reason for it to be specific to the Transport Authority, and I don't see the damage that it does sufficient to have a possibility of 30 days in jail based on the unlikely ability to afford $100,000. For, in this case, defamatory statements, you can carry a legal suit, but I think that the intent was to say quote-unquote bad words, and I find that to be an unnecessary inclusion.
Thank you, Senator Crawford. Senator Briam.
Mr. President, I hesitate to say what I'm about to say, since I know it will be unpopular. But I did spend a considerable portion of my life taking, this is not the controversial part, taking buses and taxis. And I also spent a considerable portion of my life living a much more regular life than I am now. And I came to understand that the phrase, sticks and stones will break your bones, but words cannot hurt you, is not true. And I have seen, Mr. President, many a football field deaths and other community stabbings and so on, and even shootings that start out with what Senator Damian Crawford called, is it calumnious language? Where people are told things, and sometimes I usually notice that those who are not as lyrical as others, they tend to resort to violence at the quickest. They can't respond. There are some people who are very good at the calumnious language, and they respond well, and those tend to end and fizzle out, but then there are some who are not so good, and when they think the language is getting the better of them, they then resort to violence. I feel, and of course, Mr. President, the language, like anything else, is far too aggressive. It is very easy for us to resort to language about your mother and other things, and for some reason Jamaican males think that is the worst thing that could happen to them, and they will kill because they were told something about their mothers.
Well, Senator Briam, if you saw the videos from another place, that is where it started.
I see what you mean.
With 2 licensed firearm holders.
Well, there you have it. I didn't remember that, President. I didn't remember that. Senator Allen probably was on the spot videotaping it. But so the problem I have, Mr. President, is that the language is aggressive generally, very provocative. People say things, whether it is the Transport Authority, and I confess that it is not limited to those who are on the road. People in official position, whether they, I won't call what the profession is, but some of the professions we are debating use similar language and get similar response. So for me, anything to discourage and limit the use, I am leaning in favor of it because I think that it creates opportunities for violence, and I have seen it played out time and time again. The second point I want to make before I take my seat, Mr. President, is the question of, we were talking about the Road Traffic Act regulations earlier, and of course, similarly under this one, where there are public passenger vehicles and the accidents that happens, and indeed some of the accidents are actually quite grievous. Interestingly, when I used to, in the law, deal with personal injuries, it used to be said it is cheaper to die than it is to be greatly injured. If you die, the money is fairly limited, and they have a formula, and they calculate it, and if you're not like Senator Bunting with a few degrees and so on, you don't get as much money for your life as if, and if you're a child, and they say they don't know what you would become, so they can't really say what salary that they should use to calculate your lifespan and so on. You don't get a substantial amount of money for the loss of your life in the system. What you get is, because they estimate the type of salary you might have earned, and they multiply it by a figure. So if you weren't earning a large salary, you might get very limited amounts. However, you have those persons who suffer grievous harm, they are not able to walk, they are crippled, and so on, and they now get substantial sums, because you have the medical treatment, you have care for their nursing care and so on, and lots of amenities. And I say they get substantial sums, they get awarded substantial sums. They don't necessarily recover it. So a person who's driving in a taxi, insured for $5 million, yes, and 3 persons are injured, and when you put all the awards together, it comes to $50 million. And of course, the owner or the driver have no resources to deal with that situation. And Mr. President, when the families now have to take charge of that individual who used to hustle and up and down on his own, he's 25 years old, or she, because sometimes she's a passenger and so on, 25 years old, and a mother who is semi-retired, was a helper and so on, she has to give up the job. She has to give up the job to try and stay with the daughter or the son without resources and so on. And it's an area that we have to consider very carefully, because even in our welfare programs, that you do have young people who are consequent and religious, and violence or motor vehicle accident, consequence and such matters, they suffer grievous harm without resources to take care of them. I hesitate to say we need to look at insurance, because of course if you increase coverage, you also will have to increase premiums. But at the moment, I think the coverage for the average injury that survive, that don't die, survive, is too low. So the insurance company pays what they are supposed to pay. One person, I heard of a coverage of a settlement recently of $150 million. There's absolutely no policy that goes anywhere near that. And I'm not saying it should, but maybe what we have now is in fact too low. I think it is. And we have to consider somebody have to take care of these people when they are maimed and injured. Not to mention those who don't bother with insurance at all. They forge the certificates. And some of the forgeries are so good, Mr. President, that sometimes insurance companies themselves have difficulty determining that it's not theirs. Yes? So that, with the numbers of persons who are injured on the road every day, 400 and more, and some of them badly injured, Mr. President, there is an untold story of suffering. When they leave the scene and they go to hospital and they are patched up and they are now to survive now for the next 30 years and they are not able to walk, some of them are in bed, some of them have what is it now, not colostomy, whatever the bag name. Thank you very much. That has to be dealt with. I mean, Dr. Longmore, Senator Dr. Longmore, maybe we'd better be able to speak of this. But the public system, don't encourage her. Well, I think so. Today, I say, the public system and our consciousness, until we see it personally, don't understand the untold damage. So I agree with anything that can reduce it, as these bills and the regulations will do, Mr. President, but we need to consider what else we can do in an attempt to support those who are victims of our misbehavior on the road. Thank you, Mr. President.
Thank you, Senator Braham. Senator Bunting.
Thank you, Mr. President. And just to say, we're generally supportive of the bill. Just two clarifications I'll ask the Minister to respond to in her closing or questions. On clause 9, we're introducing a new clause 13(1)(d), and this clause gives an inspector or a constable, or let me read it, an inspector or a constable may at any time carry out an inspection of 1, drivers and conductors of public passenger vehicles, 2, drivers of commercial carriers, and 3, the licenses held by the persons referred to in subparagraphs 1 and 2. What constitutes an inspection other than the license? I'm just curious. An inspector or a constable can say, give me an inspection. But could we define what constitutes an inspection? What are they inspecting? Is it limited to a uniform, a badge, or it's not the licenses, because the licenses are dealt with in a different subparagraph. So if the minister could just clarify what constitutes an inspection. It's not a defined term in the bill. The second section of that same clause 9, but now in the new section 13(2)(e), and that reads, Mr. President, an inspector or constable shall have power, E, to enter during office hours the business premises of a holder of a license issued under this act for the purpose of examining the books, records, or other documents relating to the transport business carried on by the holder of that license or exclusive license. I'm a little puzzled why any constable or inspector needs to have that power to enter onto someone's premises without a warrant at any time during their business hours. We don't know what kind of disruption that may cause for the purpose of just examining the books, records, or other documents relating to the transport business. It seems to be too wide to me, and we should either, require a warrant for that sort of search or examination, or make it just not just giving that general power to enter any time. It must be on they reasonably suspect something to be out of order why they would want to do this. So if the minister would just respond to those two specific concerns when she closes, I would appreciate it. Thank you, Mr. President.
Thank you, Senator Bunting. Senator Campbell.
Thank you, Mr. President. I'd just like to make an observation in relation to, and just following on from Senator Bunting's observation in relation to paragraph 13. Whereas I appreciate that the Transport Authority operates under its own provisions. Yet here we have a constable being authorized to effect a seizure of a motor vehicle. And if and when such a seizure is effected, in the unlikely event that the matter is brought before a court and that vehicle has to be returned to the licensee, and the court finds that there was an unauthorized seizure, that license holder, then brings an action against the Transport Authority, which has its own budget. And an award is made by way of damages to the license holder. The seizure having been effected by a constable who is not an employee of the Transport Authority. Is the Transport Authority in such circumstances obliged to make good those damages which have been awarded by the court by reason of the failed seizure, if I may so describe it, on the Part 13 of the Act? It does concern me because it's pretty easy to deal with those matters where people do not have road licenses, and if in such circumstances the Transport Authority, if it is an inspector from their entity that commits the wrongful act, then the Transport Authority pays. But in circumstances where the provision here says an inspector or a constable, and the constable not being an employee, I just like Minister to inquire of the technical people as to whether in such circumstances the award of damages would then come from central government as opposed to that coming out of the coffers of the Transport Authority. Thank you.
All right. Before you heard the query from Senator Campbell.
Mr. President, if you could just if you could give me leave for 2 minutes to just get something clarified, I don't know if you need a full recess, but, but I'm guided, Mr. President.
All right, go ahead. Yes, Minister, your time.
Thank you, Mr. President. Mr. President, I note the two members of the opposition who inquired. One or two, okay, can start. Just to indicate that these provisions haven't changed. They are in the existing Transport Authority Act. The only difference, in fact, here is that in D, it's broken out to 1, 2, and 3, but that's what it provides for now. Similarly, the inspector or constable to enter an office during business hours, it's also provided for. Same exact language, save that the act that it references is slightly different. It's the old act that it references. So the provisions have not changed in this regard as to what the original policy intent was in terms of circumscribing. So what I understand is that in respect of inspection of the individuals, inspection is taken in the normal meaning of the word, and that is to, as they do now, to inspect for badges, inspect for uniform, inspect for the validity of your license. So that's what's there, and that is what is specified further in the regulations when they shall have come. But this is what exists now in the law, and it is how it is conducted. Same with the inspection of the office.
The only thing I would say, that original law was passed before our constitutional amendments in 2011.
But also just to indicate,
so rights to privacy, etc., are much more recognized and justiciable now than they were then.
And perhaps what's important is that that's why this has 13C, which is new, and 13C is the protection of any documents covered by legal professional privilege. It carves them out, and that's on page 16. So that's not in the old law, but that's there now. So that's the movement of the clarifying the common law position in that regard. Just to say, there was a question raised about the requirement for a police report, and just to say that regrettably, I think unfortunately we're unable to look into someone's eyes and know their heart. The only thing, the best and closest you can get to secure a public service, a public transportation system, to understand the persons who are nearest and engaging directly with members of the public, vulnerable and invulnerable, is to request a police report. It's quite simple. And it is never specified to say what it is that you are looking for in a police report. The Act actually doesn't provide for the requirement of a police report. I was saying that this is one of the things that will be required under the regulations. What it does say in the Act is that what is fit and proper, because it says that people who are operating in the transport sector must be fit and proper, but it distinguishes between what fit and proper means. So if you're a company, then it has that more usual corporate definition you would see. And if you're a conductor, it refers more to your ability to move in and out, but also it refers generally to people, and therefore also to conductors, about there being, and I quote, no circumstances that are likely to lead to improper conduct in the provision of public transportation services. So that's quite broad. Whether you require a police report or not, this provision will say that you must assess who it is you're having engaging with members of the public in areas where they exercise any power or authority over them. And this is not an unreasonable thing if you are trying to move from mayhem to safety. So I don't think that there is any mind to go backwards on this. I think this is, we are quite clear. We are trying to reset and re-engage in a sense of safety and to have persons have a pleasant experience. The whole issue, the issue of calumnious language, we've addressed the fine, the level of the fine, and the level of potential imprisonment, or jail really, not imprisonment. And that will stay because, again, there is a general principle of seeking to institute or to reinstitute a sense of order. Public order has more than one element, and it's not just, it's not about the violence at the extreme. It is about the language which Senator Braham referred to, that can in many cases be the precursor to violence, or it can simply engender such a sense of insecurity and aggression that it speaks to disorder. So it's not going to be removed. It is in fact the provision that's not just about speaking broadly, it is addressing an inspector in an abusive or calumnious manner. And then there is also the incitement to so do, which is another offense under this act, which is being amended here by bringing down that fine as well. Also in the amendments, let me just be clear, there's the use of threatening language or the exercise of behavior which is threatening, and the incitement of persons to hinder or resist or assault an inspector in the lawful carrying out of the inspector's duties. These are the amendments which are treated with in this list in respect of fines. And again, so this is about order. It's not okay to incite aggression against an agent of the state or who is seeking to provide an orderly public transportation system. Public inspectors must be, conductors must be, drivers must be decent and courteous as well. So this is not to remove the burden from them. They are also dealt with in the Act, and they will also be treated with in their regulations. But this is about saying that all stakeholders, both the providers of the service and the users of public transportation services, must, there's no reason why taking public transport should be the distasteful experience which it is. All over the world, people take public transport, and it is decent and orderly. People know what their role is. If my job is to let you on the bus and let you off the bus, then I can do that without trying to touch you or engage you in all manner of inappropriate discussion. It's not necessary. It's not normal. And we're accepting these things as if they are normal, and it's okay, it's just culture. Yes, culture is strategy for breakfast every day. In a corporate setting, that's great to speak about, but to accept the most damaging parts of what has manifested or is now manifesting as culture as a part of who we want to be as Jamaican, not in Jamaica 60. Let us try to imagine a better society where people can go to work and to school feeling comfortable and safe, that you don't have to be thinking about whether you wear the nice necklace you get for your birthday or you keep it in your purse and maybe put it on when you get to work. No, you must be, that can't be the life that we want for Jamaicans now. We have to want better, and it starts right here. It starts with setting the rules. So that is what I have to say about calumnious and abusive language. And I will also put under that umbrella in regards to the reports, the argument that we don't have any data that the people who are perpetrating the sexual offenses against users of the transport system, that they are repeat offenders. As an argument to say that we should not require a report because it won't be helpful. There is, there are arguments that it's okay to have within, a sort of academic context within which there are no consequences for your words. But to say that because you may not have detected an offender or he may not have been punished yet as a reason that you shouldn't be asking for proof that someone is not an offender cannot be a basis for proceeding in strengthening your transportation system and in making it peaceable, safe, and orderly. So this is what we're seeking to do here, Mr. President, and I do hope that in this context we may proceed to committee and have second reading of the bill. I thank you.
Thank you, Minister. The question is that the bill be read a second time. Those in favor? Those against? The ayes have it.
A bill entitled the Transport Authority Amendment Act 2022, read a second time.
Mr. President, I understand that there are no specific requests for amendments, so if you could take it in blocks, perhaps by part, it might help us to move a little more quickly. Thank you.
All right, the Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause.
And I just say, Mr. Chairman, if you read the fit and proper definition in the bill, I think it perhaps would outline the offenses for which a police certificate would expose if a person had those, for example, he has not been convicted of any offense involving fraud, dishonesty, or moral turpitude. Right. So when you read both of them together, I don't think it's just the fact that a person may have had some offense, but an offense relevant to the safe. Yeah. So I think when you look at those together, I think it would address the concern that he had.
All right. You have an amendment sheet, right? Good. So I put clauses 1 and 2. Those in favor?
Aye.
Those against? Ayes have it. There's amendment to clause 3.
Yes, Mr. President, there are 2 amendments to clause 3. I would ask that they be taken as appearing in the list which has been circulated. One is the amendment of the term definition of an emergency road license, and the other is the reference to the fit and proper definition insofar as it concerns an individual acting as a conductor.
All right, the amendments, members, those in favor?
Aye.
Those against? Ayes have it. Clause 3 as amended. Those in favor? Those against? Ayes have it. I put clauses 4 to 13. Those in favor? Those against? Ayes have it. Clause 14.
Mr. President, again, I would ask that the amendment be made as it appears on the list circulated. This is simply to insert the words a reduction in provision of public transportation services, and this is related to the definition of emergency road licenses, which are issued by the ministry in the event that there is some emergency that creates a shortage in provision of transportation services, and something needs to be done at short instance. So this is just facilitating language.
All right, so we have the amendment to clause 14. Those in favor? Those against? Ayes have it. Clause 14 as amended. Those in favor? Those against? Ayes have it. Clause 15 to 17. Those in favor? Those against? Ayes have it. Clause 18. Is there an amendment?
The amendment to clause 18 proceeds from page 1 on to page 2. It starts by amending the marginal note to say that you're inserting new sections 17A to 17L in the Principal Act, and then in respect of 17K to insert the different means of the of service of documents, as I explained earlier. So this just speaks to registered post and electronic, and the fact of a certificate of service being prima facie evidence that the notice was served.
So the amendment, those in favor?
Aye.
Those against? Ayes have it. Clause 18 as amended. Those in favor?
Aye.
Those against? The ayes have it. So we go to clauses 19 through to 21. Those in favor? Aye. Those against? Ayes have it. Clause 22, there's an amendment.
Yes, Mr. President. This proceeds from pages 3 to 4, and this is the amendment to Part 2 of the new 4th schedule in column 3 under the heading penalty. So this is the sections that I described a bit earlier. The reduction of the fee in respect of use of abusive and calumnious language to an inspector in the lawful exercise of his duty, and that is the fine reducing from 500 to 100,000, and the 6 months being reduced to 30 days. And we also, I'm not sure if I need to go through them again because I think I just did earlier for clarity, but we have the use of threatening language or behavior which is threatening or intimidatory to an inspector while he is lawfully carrying out his duties as an inspector, not in any other circumstances. And this is reduced from 500,000 to 250,000 and from 6 months to 3. And in respect of incitement of persons to assault, hinder, or resist an inspector in the lawful carrying out of the inspector's duties, again, we've brought that down from 500,000 to 250, and from 6 months to 3. It's still serious. These are still serious offences, and they are increases from what currently exists, but we've reduced it from what was in the lower house, and these are, again, all maximum fines. These are not fixed fines. They are the upper thresholds that can be levied. There's also the incitement of any person to use abusive or calumnious. I've been saying calumnious all along. Calumnious language to an inspector. Again, this is reduced from 500,000 to 100,000 and 30 days, as in the commensurate provision, as well as the incitement of any person to use threatening language or to behave in a manner which is threatening or intimidatory to an inspector. So this is about the safety of the persons who we are asking to secure our transport system, Mr. President.
So, members, the amendment to clause 22. Those in favor? Aye. Those against? The ayes have it. Clause 2 as amended. Those in favor? Aye. Those against? Ayes have it. We move to clauses 23 through to 32. Those in favor? Aye. Those against? Ayes have it. I put the title and the enacting clause. Those in favor? Aye. Those against? Ayes have it. The question is that I do report the bill as having passed the committee stage with 11 amendments. Those in favor? Aye. Those against? Ayes have it. The schedule is in 20. I do report the bill as having passed the committee stage with 11 amendments. Those in favor? Aye. Those against? Ayes have it. Minister.
Thank you, Mr. President. Might I ask for third reading of the bill?
Those in favor? Those against? Ayes have it.
A bill entitled the Transport Authority Amendment Act 2022, read a third time and passed.
We have the
Thank you, Mr. President. Mr. President, let me do this after. Thank you. We now proceed to the third substantive item on the agenda, and that is the debate on the electricity net billing regulations, a matter which I think we agree is sufficiently important for us to have settled before the Parliament goes on recess, so that we are able to leave the technical teams with the requisite framework for their continued work on this important area. Mr. President, the regulations before us were made pursuant to, oh, hold on. I have to suspend standing orders to ask I don't think I suspended standing orders, Mr. President. Might I request the suspension of standing orders to allow me to take the motion notice of which I gave earlier?
Well, you have heard the question, members. Those in favor? Those against? Ayes have it.
Thank you, Mr. President, for good order. That had slipped my mind. But here we are, about to debate the Electricity Net Billing Regulations 2022, which were made pursuant to Section 55(1) of the Electricity Act 2015. Section 3E of the Act identifies as one of its objects the promotion of energy efficiency and the use of renewable energy and other energy sources. Members would be aware that National Outcome 10 within Jamaica's Vision 2030 is attaining energy security and efficiency. And a crucial factor in arriving at that outcome is the transformation of our energy sector from overdependence on non-renewable sources of energy, especially oil, Mr. President. I must say, I'm sure we agree that it is alarming that most of the foreign exchange earned in Jamaica, or indeed a large proportion of it, goes back into buying and importing oil. As the world also teeters on the brink of a climate catastrophe, Mr. President, nations, including Jamaica, must find ways to quickly and sharply reduce our carbon footprint. And furthermore, the effect of international shocks on international energy supply chains also brings into sharper focus the need for greater resilience on domestic sources. So increasing the use of renewables such as solar, wind, and hydro, all of which we are naturally blessed with, it is therefore important for both our economy and our environment. Mr. President, the National Energy Policy, as amended, has set a target of 50% for renewables in the national energy supply mix. In pursuit of this goal, the Energy Act 2015 establishes the legal framework for net billing, electric wheeling, and other arrangements. And net billing is defined in Section 2 of the Act as a mechanism for self-generators to sell or to be otherwise credited with the value for the excess power generated under standard offer contracts with the single buyer that have been approved by the office. And the single buyer is JPS Co. The net billing, simply put, allows for customers of JPS, the grid operator, to generate their own electricity from renewable sources and to sell the excess to JPS. And this is at a tariff equivalent to the monthly short-term avoided cost of fuel. Mr. President, assessment of the net billing pilot program pointed to the need for a stable regulatory framework to effectively facilitate the deployment of renewable energy technologies. These regulations will provide that framework, making us able to deploy a modern, efficient, and environmentally sustainable energy sector that is affordable and accessible. Mr. President, the key aspects of the regulations before us include Regulation 1, which is the citation, stating that these regs will come into operation on a day appointed by the Minister by notice published in the Gazette. Regulation 2 deals with interpretation, so we have terms like electrical inspector, commercial customer, net billing meter, residential customer. They're all defined and set out in the regulations. I will say that, Mr. President, Regulation 3 deals with eligibility criteria for net billing. That is where a residential or commercial customer is eligible to be issued with a net billing license. So just to make clear, Mr. President, that you can be a residential customer or you can be a commercial customer, and you can, this means essentially if you set up your solar system, you can sell your excess, whatever you don't use, you can sell it back to the JPS, and that allows you to lower your bill when the costs of your provision of that service and your use of the electricity and sell to them. So just to explain a bit more about this, this service, net billing and the criteria for you to be able to do this license, to obtain this license, is set out here. So net billing is open to all applicable and qualified customers of JPS. That is a single buyer, limited only in circumstances where the generating capacity for the licensed renewable sources to be connected to the grid is reached. So the limit on the number of licenses to be issued at any time is prescribed by the Integrated Resource Plan. A net billing license may be issued only where the single buyer is required to purchase such energy at the net billing energy rate published by the OUR, subject to a contract to be executed by the licensed self-generator and the single buyer. So you enter into a contract with JPS, essentially for JPS to purchase the energy from you at the net billing energy rate. Regulation 4 sets out the obligations of the single buyer to implement service to other customers. So Regulation 4 establishes that the single buyer must implement net billing arrangements once the eligibility criteria set out in Regulation 3 are met, and that the net billing arrangements do not negatively affect the service that they provide to other customers. Regulation 5 specifies the process, the application process for an applicant to be licensed for a net billing arrangement. So they have to submit a license to an application to the minister, along with documentation specified in Part A of the schedule to these regs, and with a proof of payment in accordance with Part B of the schedule. On receipt of the application, the minister shall review the application and advise the applicant where the application is incomplete to submit additional information and documents. The applicant would then have 60 days in which to submit any additional information and documents requested, and if the applicant does not so do, then the application process may be terminated. The net billing contract is treated with under Regulation 6, and it states that where the license is granted, the single buyer has 30 days from the date of receiving the license to issue a standard of a contract approved by the OUR. So if someone has a license and goes to the JPS with it to ask them to enter into the net billing contract, JPS must give them that contract within 30 days. Under Regulation 7, the regulations deal with the failure to commence net billing. So it stipulates that where a license is granted and the self-generator fails to commence net billing within 12 months, that the license must be revoked. So there's an obligation on both sides with under Section 13 of the Act. That's under the Electricity Act. The net billing contract itself should be terminated, and the single buyer will be discharged of any obligation to connect the self-generator to the system. So notwithstanding the previously mentioned, this regulation also specifies that the self-generator may make a new application for the license in respect of the same generation set. So if something went wrong and they had not been able to generate and therefore to enter into the sale of energy, but and their arrangements are terminated, they can reapply. Duration of net billing is addressed under Regulation 8, and it says that the license shall be valid for 10 years, and the duration must not exceed the period stipulated in the net billing license, duration of the net billing contract rather. So the contract and the license must be coterminous. Regulation 9 speaks to the use of system charges. So it establishes that a self-generator who enters into a net billing contract must pay a monthly use of system charge to the single buyer approved by the OUR. And the purpose of the use of system charge, Mr. President, is to compensate the single buyer's transmission and distribution system. So this use of system charge must not be a part of any other rates payable by persons who have not entered into a net billing contract. So this is about the fact that JPS is providing service to other people using its network who are unable to enter in such contracts. And the ability to enter into a contract shouldn't prejudice the broader customer base of JPS. Regulation 10 deals with security deposits and insurance coverage. And if the single buyer does not Regulation 10 prohibits the single buyer from requesting from the self-generator security deposits and insurance coverage for the net billing arrangement. And if the single buyer requests those undertakings, then the single buyer is liable to a fine not exceeding $2 million. And regarding the sale of excess electricity, this is dealt with under Regulation 11, where a self-generator must not, while selling electricity to the single buyer for net billing, at the same time connect to the system for wheeling or any other arrangement using the same meter. So wheeling is where the self-generator provides electricity to the system on terms pursuant to which the wheeling beneficiary shall use an equivalent amount of electricity from the system at one or more locations. So you can't bring in other systems into your net billing system, other wheeling systems within your, on the single meter. Under a wheeling agreement, a self-generator is neither buying nor selling power to the JPS. Instead, the wheeling agreement allows the self-generator simply to pull from the grid at a destination the same amount of energy it had put on the grid at the place it was generated. So it's a little different from generating an excess and having that be a part of a billing net-off arrangement. So a self-generator who is connected for net billing and for wheeling or any other arrangement using the same meter is liable to a fine not exceeding $2 million. Regulation 12 deals with overall excess electricity, and it allows for an excess generation capacity limit to be set by the Integrated Resource Plan, which is reviewed periodically under the planning process in keeping with the planning and development of the system. And by this process, a generation capacity ceiling for the total number of licensed generation capacity for all self-generators engaged in net billing is established. So there's a ceiling for all of this to be done, and that's set under the IRP. The regulation also specifies that where the generation capacity limit has been reached, then no new net billing license must be granted until the prevailing capacity is adjusted. And whether that is by raising the ceiling or changing the power system dynamic, the power supply dynamic. Regulation 13 deals with capacity of supply of electricity by the self-generator. So it states that a self-generator mustn't supply electricity to the system for net billing from the same generation set to more than 1 meter. It also prescribes that a residential customer, a self-generator residential customer, must not connect to the system in excess of 10 kilowatts for net billing, and a commercial must not connect to the system in excess of 100 kilowatts for net billing. The capacity on supply of electricity by a self-generator should be reviewed by the OUR and the minister every 2 years. Regulation 14 deals with the obligation of the self-generator to implement net billing, and the cost of the electrical equipment and apparatus supplied by the single buyer to the self-generator must be approved under this section by the OUR. Regulation 15 deals with restriction on the self-generator from connecting the generation set to the system. And the restrictions are that this mustn't be done unless the self-generator receives a net billing license, has executed a net billing contract with the single buyer, receives certification from a licensed electrical inspector for compliance with the required specifications, and received approval from the single buyer for the actual grid connection. Excess electricity is dealt with again under Regulation 16, but in this context, it is requiring the metering of excess electricity supplied from the self-generator to the single buyer using a net billing meter purchased from the single buyer. And it must be that there are specifications for this that are provided in that same section. Regulation 16 also provides that if the net billing meter is found to be inaccurate or malfunctioning, both the single buyer and the self-generator should aim at arriving at an agreement on the amount of electricity actually consumed or supplied and any amounts payable. And if the single buyer or the self-generator, if they fail to agree, the matter is referred to the OUR for resolution. And within 2 weeks' notice by one party to the other, a request may be made to the Bureau of Standards to test the net billing meter at the expense of the requesting parties, finding fairness. Regulation 17 deals with the monthly net billing statement. It requires the OUR to approve and publish the rate to be paid or credited, and the single buyer must generate and provide a monthly statement setting out electricity consumed and electricity supplied, and the monthly payments, of course, to be made by either party. Disconnection is dealt with under Regulation 18, outlines the conditions under which the single buyer may disconnect a self-generator from the system So non-payment of electricity consumed, net billing contract expiration, and where the license is actually revoked under Section 13 of the Act. Regulation 19 addresses disputes and has the OUR as the arbiter in those matters, and it requires the OUR to maintain a complaints register. Regulation 20 addresses compliance with relevant permits and licenses, and again, that's Regulation 20. If the single buyer or the self-generator contravenes the provisions that are set out here, either one would be liable to a fine not exceeding $2 million, or in default of payment to imprisonment for a term not exceeding 1 year. Regulation 21 imposes certain duties on the self-generator, including maintenance of the generation set for safe operation and keeping proper maintenance records in relation to the generation set, and rectification of any defect in the generation set except for the net billing meter up to the interconnection point. And here, where the self-generator doesn't conform, the fine is again not exceeding $2 million, or in default, imprisonment not exceeding 1 year. The maintenance of the net billing meter system by the single buyer is required under Regulation 22, and under Regulation 23, there's a provision for reasonable notice to be given to the self-generator if the generation set is to be examined. Regulation 24 deals with tampering with the net billing meter. It creates a summary offense if someone tampers with a net billing meter, and again the fine is $2 million, not a fine not exceeding $2 million, or in default, imprisonment not exceeding 1 year. Regulation 25 creates the offense where a person contravenes the regulations and unlawfully connects to the system. Here, the offense is, the person rather, is liable to a fine not exceeding $5 million, or in default, imprisonment not exceeding 2 years. Mr. President, there is a schedule to the regs, and they are divided into two, Part A and Part B. Part A contains the application form for a net billing license and a submission checklist of documents referred to in Regulation 5, and Part B sets out the applicable fees for Regulation 5. So, Mr. President, in sum, these regulations do set out the framework to allow for persons to, and incentivizes in a way, persons to seek to use more renewable energy and to thereby create a greener environment, while also seeking to achieve more broadly energy security and efficiency. So it's seeking to incentivize the use of renewable sources of energy while reducing our carbon footprint. This is a good point in time, Mr. President, to close this debate, or rather to close my opening, and to seek the input of others who may be interested in contributing thereto. Thank you, Mr. President.
Thank you, Minister. Senator Allen.
Yes. Thank you very much, Mr. President. You know, the business of renewables and energy efficiency and incentivizing customers to go in this direction is something I'm not sure why more of us are not seriously contemplating and utilizing renewables in order to better manage our use of energy and our cost, the cost to our pockets. When I was asked, or when I was given the opportunity to sit on the Joint Select for the review of the Electricity Act, I was somewhat intimidated by the Electricity Act because I don't know anything about electricity and it's very technical. But now I'm a bit more familiar with terminologies like wheeling and net billing and single buyer and all these things. Yes. And self-generator and all these things, which really boils down simply how I, as a user, could be a self-generator and therefore utilize renewables, convert it to electricity for my own personal use, and then calls for the single buyer, JPS, to purchase or to utilize. You know, it seems technical, but it's rather a simple process. And at the end of the day, when I look at my utility bills, my JPS bills, and now listening to the presentation even in greater detail, I am convinced I need to take certain action. But it's a major investment which should be incentivized in order that we, as users of electricity, can find it more likely that we can go in this direction. And at the end of the day, as the Minister points out, the objective of Vision 2030, where we are seeking to get to a place of energy security and efficiency, that we can achieve this as a country as a whole. And as I speak of Vision 2030 and the fact that these regulations, which are in alignment with the revised or the introduction of the new at the time Electricity Act of 2015, we are a few years late in seeing the regulations. And we're now going through the process of reviewing the Electricity Act, which should have been within a 5-year period. So we are behind the 8 ball on a very critical matter called energy. So what that says to me, and should probably say to all of us here, is that we are not as efficient in the process of legislation in order that we can get to the place where we say we want to get to. There was a time when Vision 2030 seemed very far off. We are now 8 years, 7.5 years away from 2030. So we must realize that it's an urgent situation, and therefore the resources that are required in order for us, and this is not casting blame one way or the other, it is just stating a fact that the legislative process, whether it is the review of acts, whether it is the introduction of regulations to support the revision to acts, or just the entire process, it is not keeping up with what we ought to be doing in order to get us to where we need to get to. And that's a responsibility of all of us here. And it speaks to the need, the urgency, the need for the investment in that area in order to get us to that place. So there is no objection at all to what is presented here. There is consistency in the views. I note, however, and would like to get some clarification from the Minister, I note that with regard to all but one of the offenses, that the fine is very consistent. It's the same, really, not exceeding $2 million or 1 year. And when I look at one of the likely breaches, which is a person not getting a license for net billing and at the same time wheeling. So you are on one hand benefiting from net billing and then bringing on other entities or other operations onto the system. An entity, a person could benefit significantly and save tremendously. And so when we look, and the size of it, it doesn't speak to the size. And therefore, when we say the fine is not exceeding $2 million, is to get an understanding of the calculation or the determination of that fine and whether it is consistent with what could have been lost. I'm sure there is some calculation that the technical teams would have gone through to determine this fine, but just for clarity to understand, because if not caught quickly, someone could end up saving significantly or benefiting from being a net biller and a wheeler at the same time. I feel so smart saying net billing and wheeling. I could go into electricity business. But generally, though, there is no contention on this side with regard to these regulations. They are long in coming, 7 years, but it is my hope As a matter of fact, these regulations have not affected the fact that net billing has been going on. It has happened. So this is not going to necessarily change anything significantly. It's really putting it into effect, something that is already happening. But what we would hope is that at the next cycle, where we are anticipating a revision to the Electricity Act, that we not end up in a situation where the likely revision to the regulations are not far from the point of the implementation of the new act, because we wouldn't want such a critical area that is impacting so much in so many different ways, like electricity, to be hindered by the tardiness of the process. So with that, Minister, and with that, Mr. President, that's my contribution to this. We support wholeheartedly these regulations and look forward to them actually coming into effect. Thank you.
Thank you, Senator Allen. Senator Campbell Rodriguez.
We would think when you talk, I do have a problem. So, yes, Mr. President, when it comes on, like the speaker the senator who just spoke, electricity just doesn't seem like something that I'd ever want to talk about. But in actuality, it is such an important thing. And also, someone sent me a text a few days ago and said they heard the minister in that other place talking about net billing, but they weren't clear what it was. And it goes to what we often say here. We need to communicate a little bit more, and we do need to ensure that the average Jamaican understands what we're talking about. Because net billing is one of those things, as was explained, you produce energy as an individual or on a commercial basis, either using hydro, wind, or solar, and you're selling the excess that you're not using to the single buyer, who in this case is JPS. And this is something that is not only beneficial in terms of the environment and in terms of energy security and in terms of resilience to shocks and all of those things that we have spoken about, but it's also income generating. And that's something that we often overlook when we talk about these things, that this is an opportunity as well, because there are provisions for commercial suppliers to the grid, to the single buyer. And, the war that is now taking place in Europe has made this something that seems more urgent for Jamaica to become more reliant on renewable sources of energy. And the whole discussions around energy security have taken a pride of place that they didn't have a few years ago. And so these regulations, while they may be late in coming, they are here, and we need to ensure that they get through the process and it all begins. And I just want to take the opportunity, Section 3 of the regulations, eligibility criteria for net billing. It's very important because it speaks to the integrated resource plan. And the integrated resource plan speaks to the amount of energy that the single buyer will be able to take over a period of time. And this first phase, up to 2025, they can take 300 megawatts of solar and or wind and 74 megawatts of hydro. And it is important because anyone who is looking to do it needs to understand, once that level has been reached, no more will be taken for this first phase. But, Mr. President, just, I know the conversation has been had, or the comments, that net billing has been happening for some time in Jamaica. And yes, since 2012, I think, or 2013, thereabout, there has been net billing in Jamaica. But this regulation serves to formalize that process, which is always important. And in 2015, we had 200 licensees. By 2021, that number jumped to 800. And by June of this year to 1,023, which means there is some interest in it. And I think with the passing of this legislation, we open the door to more people understanding that it is something that can be done and probably should be done. And I think, Mr. President, with the removal of GCT, which was announced by our Minister of Finance a few months ago, or a few weeks ago, removal of GCT from lithium-ion batteries, which are the batteries used to store energy generated by solar panels, it is an opportunity for more persons to consider net billing. I just saw the electricity bill of someone with solar, and the electricity bill for the month is less than $1,000. And so with the removal of the GCT from the batteries, persons who already have solar panels can look to invest in more batteries. And from there, using the net billing regulation as a guide to supply to the JPS. Just 2-3 quick recommendations. Firstly, we need to proactively encourage the use of these hydro, wind, and solar. And secondly, the number of kilowatt hours that residential self-generators can supply is 10 kilowatts, and commercial, it's 100 kilowatts. And I just want to suggest that in the future, when we renew this, we contemplate increasing those numbers. I'm not sure what the thought process is, Minister, why we stopped at 10 and 100. Is there a reason why it's only 10 kilowatts for residential and 100 kilowatts? I think it's something we should look at in the next go-around to increase. And secondly, a meter is to be used for net billing. It is to be purchased by the self-generator from JPS. The minister in his presentation in the other place said that the price for the meter is the purview of JPS. I just want us to ensure that we at least, the OUR or whomever is responsible, at least ensures that the cost for that meter is not prohibitive or it defeats the purpose of what we're trying to do with net billing. So all in all, I'm in support of these regulations. I'm happy for them, and I look forward to the positive impact that it will have, not just now, but in the future for Jamaica.
Thank you, Senator Rodriguez. Senator Bunting.
Thank you, Mr. President. I just wanted to point to one real policy concern. And while the regulations themselves didn't set out the specific price for the energy supplied to the single buyer by the self-generator, and we know that is a price set by OUR. The formula is set by OUR. In practice, the self-generator gets a severely discounted rate, which is to compensate the JPS for maintaining their distribution infrastructure and in effect having their generating system as a standby for the self-generator. But when we look at the economics of it, actually, net billing is much less attractive than just generating for your own consumption. And what we are, I believe, at risk of seeing, Mr. President, is that the most attractive customers, your blue chip commercial entities, for whom capital is no constraint, they will put in, the big listed companies like Senator Webby's will be able to afford their own self-generating operations, their own generating capacity for their own consumption. That will give them the best yield, because instead of getting a net billing, they will their savings will be the full opportunity cost of buying it from JPS. Similarly, on the residential side, generally the biggest customers who are reliable payers, are the ones who can also afford to put in their solar and their lithium batteries and their self-generating system. In fact, I just put in a system myself, and the payback period is quite short. It's 4 years. Now, what we've then created is a perverse incentive that the best commercial payers, the best commercial clients, the ones at the top, the industrial and commercial consumers, they will come off the grid. Then the best residential customers will come off the grid. And the overheads of JPS will be applied over fewer and fewer customers. So the rate per kilowatt hour will go up. That will make it unaffordable for fewer people, or rather make it affordable for fewer people and make it unaffordable for more persons. So chances are the loss to theft will increase. So there is a bigger policy concern that we don't create a sort of squeeze from both top and bottom, so that the customers in the middle are facing higher and higher rates. And these rates, quite frankly, are to an extent almost independent of the fuel charge, because the reinvestment that JPS made, or even the private power generators have made, they have to recover those overheads. So even when fuel charges go down, we're not going to see our bills go down in proportion, because a bigger chunk of our bills is the amortization of the capital investment that the companies made in fairly recent times. Now, it's a good thing in terms of reliability, because replacing I remember we used to know the boilers at Old Harbour Bay by name, number 4 and number 2, and because they made our lives interesting. and we really not seeing that, certainly not to any similar extent, no. But we have that fixed overhead that is going to be amortized over a very long period of time. In the meantime, the best customers at the commercial level will be coming off, or certainly reducing their consumption as they replace with self-generating, whether renewable or otherwise. The best residential customers will likely also be moving in that direction. And I think it's going to create a squeeze on those customers in the middle, and create an incentive for the customers who can't afford it to use the throw-ups, or for people not to come off using the throw-ups. And it's really a bit of a policy challenge. And I think it's one that we need to address before it becomes a crisis. You might say, but why would we be concerned? Because the JPS is privately owned. So it's the risk of doing business. But at the end of the day, if it is, if the JPS becomes insolvent, we can't lose our electricity grid. The government would have to step back in and take it over, and it would once again become taxpayers' problem. So it's a policy issue that I think that must be addressed. It's not addressed explicitly in this set of regulations, but this regulation highlights the difference between those who generate solely for self-consumption and those who generate with a view of selling some portion to the grid. And the differential in price is so dramatic that somebody who is making a shrewd financial decision would try and match their self-generating output as closely as possible to their own consumption to avoid having to pay JPS, that large portion of the revenue to compensate them for maintaining the infrastructure. So those who only put in self-generation up to, say, 95% of their capacity, of their self-consumption needs, and use JPS as a standby. JPS gets no consideration for that like they do from the net billing customer for maintaining that infrastructure and that generating standby capacity. And so I think we have to be very careful of the incentives that we create. As a consumer that has a self-generating plant, is good for me. But if I look beyond just those of us who can afford to put in our own solar systems with batteries, and we look at it from a broader public interest, I think it's something we need to address. And it was highlighted to me, I just came back from a visit to Barbados. In Barbados, all the self-generators sell to the grid. They're obliged to sell to the grid, as I understand their system, and then they purchase back from the public utility. In that case, however, they're paid a much higher percentage. They still get a lower rate for what they sell to the grid than what they buy back from the grid, but the difference is not as vast as it is in our circumstances. So that was their way of addressing it. I'm not saying that we need to follow that path, but I think there is a clear public policy issue that we should study and address before it becomes a crisis. Thank you.
Thank you, Senator Bunting. Minister.
Thank you, Mr. President. And I think it is going to be very easy for me to respond to everyone today, because the fact is that these issues are why the Electricity Act is now being reviewed, because we are very much aware of that potential challenge and an undue burden being created for the average consumer, and in fact the most vulnerable consumer. And that must be protected against, while at the same time ensuring that you are incentivizing right behaviors for the environment, for the economy. So there is a tough balance to be achieved, and that lies in the review of the IRP, the Integrated Resource Plan, which is scheduled to be reviewed as at the end of this year. And it is intended, and if I understand correctly from the Ministry, from MSET, it is hoped that the review of the Electricity Act will be completed to be complementary of that review, so to set the framework. So we're very clear that there are some policy issues to be addressed, including the setting of the kilowatt, because so far as my understanding is, that is to allow for a number of persons to be able to do it at that level, rather than to have the larger players simply go to a max capacity and be able to use up all of the space that exists within the ceiling set by the IRP, which I referred to earlier. On the function of the homogeneity, I will call it, of the fines, that answer I actually don't have today. I could try and get it from the ministry for you, or since you're on the Joint Select Committee, I hate to ask you to ask, but you'll have all the technical people there, and it might actually happen more quickly for you directly with follow-up questions as well. So, Mr. President, there being a sort of broad acceptance of the importance of having these regulations in place, not because it changes what occurs now, as what occurs now is the practice based on the pilot, but it will ensure that there's the appropriate institutional framework, which will be in good stead leading forth, of course, the review of the Principal Act, which is underway before Joint Select Committee. I would therefore ask, Mr. President, for second reading of the bill, that we move to committee. Oh, no, it's regulations. It has been a long day, but so I'm going to ask, Mr. President, that the motion, notice of which I gave earlier and which we have just debated, be approved. Thank you.
And members, the question is that the motion, notice of which the Minister gave earlier, be approved. Those in favour? Those against? The ayes have it.
Mr. President, might I ask for the recommittal of the item?
Members, recommittal motion. Those in favour? Those against? The ayes have it. Announcements.
Also laid on the table of the Senate today is a copy of the report of the Joint Select Committee on its deliberations on the bill shortly entitled the Firearms Prohibition, Restriction and Regulation Act 2022.
All right, so
So we're just asking that all members, if possible, receive a copy of that, even if it has been circulated electronically. Sometimes good to have a hard copy at hand. Well, if it's not yet, it was to be. No, but circulated to us here, senators here. Okay, I don't recall seeing it, but it could have been. It could have been. I won't swear. Yes. Mr. President, I have one matter left for us today, and this is noting that it is not contemplated to do any further business. However, I am asking that, that this House adjourn until Friday, August 5th at 3 p.m., notwithstanding Standing Order 8.1, which stipulates the day and time allotted for sittings of the Senate. Mr. President, as members should have heard already, this meeting is so scheduled to facilitate a joint meeting of the Houses of Parliament in commemoration of the 60th anniversary of Jamaica's independence.
all right, before I take that and bring this to a close, I just wish to bring to the attention of the Senate of the passing of a former member of the Senate, Mr. Barrington Anthony Warman, who had passed earlier this week. As I indicated, he is a former senator, one of our own, a man of principle, a man who believed in the service to his people. He served in this Senate during the 1976 to 1980 term. And in the political arena, he also served as a councillor for the Caron Hall Division in St. Mary during the 1970s. Mr. Warman was also involved in the agricultural sector and was not only a dedicated farmer, but also one who served for 2 terms as chairman of the board of the College of Agriculture, Science and Education. He's a man who wore many hats. Mr. Warman was also a real estate developer and evaluator. We in the Senate appreciate his service to Jamaica, and we express our deepest condolences to his family. His wife, who had predeceased him, but he has 6 children who he leaves behind. May he rest in peace, and may light perpetually shine on him.
Mr. President, if I might just, well, let me...
Go ahead.
No, just to say that, of course, we join in the condolences extended by you on behalf of the Senate, and appreciate your having brought the matter to our attention. Some of us may have heard, but it is always good to ensure that the record reflects these matters, and that, of course, that the Parliament convey to the family so that they know that service is remembered and that their loved one is indeed still kept close. Mr. President, if I could also just indicate by way of reminder that the joint sitting of the Parliament will also facilitate the special attendance of His Excellency President Hage Geingob and his First Lady, who will be our guest of honor at our Jamaica Independence or Jamaica 60 celebrations, and he will make a presentation at that sitting, and therefore it is really hoped that the Senate will be well represented showing our Namibian brothers and sisters our warm Jamaican hospitality and love, and indeed their warm reception within this Parliament.
Mr. President, I don't want to take the last word from the Minister, but we want to, undecided, join in expressing our condolences to the family of former Senator Barry Warman. He was a humble man. He was honest in his dealing. He was a regular caller, I know, to Monty Perkins, and we're saddened by his passing. And as I say, we too want to be associated with it. And as the Minister said, we expect the normal courtesy to be sent to his family from the Senate. Yeah.
All right, thank you, Senator Brown. So, Ms. Curtis, you are so directed. So, in respect to the adjournment, as moved by Minister, the question is that this Senate be adjourned until Friday, August 5th, 2022 at 3 p.m. And at that time, we will be facilitating a joint meeting of the House of Parliament in commemoration of our 60th anniversary, at which we will be hosting the President of the Republic of Namibia and Her Excellency Mrs. Monica, I hope I get this pronunciation correct, Gaingos. Good. And as we all know, moving into this weekend, we'll be having the start of our emancipation celebrations, going into our independence celebrations, and right across Jamaica, based on various schedules that I've seen, in the capital city, in St. Ann, there are significant activities taking place in Western Jamaica, also in Montego Bay, and in other areas across Jamaica. Various municipalities will also be hosting various events. So wherever you are in Jamaica, you should be able to attend one of these activities and to ensure that Jamaica has a peaceful emancipation and celebrate the 60th anniversary. So at this time, on the motion, this Senate now stands adjourned. Thank you, ladies and gentlemen.
The Jamaica 60 Diamond Jubilee crowns its queen, and you are invited. Join us as festival queens from all parishes across Jamaica come together at the National Indoor Sports Centre for the grand coronation. The talent, the fashion, the personalities. Who will be crowned? Join us at the National Indoor Sports Centre on Emancipation Day, August 1st at 4:30 p.m. or catch us live on TVJ and PBCJ.
It's Jamaica's Diamond Jubilee, celebrating 60 years of independence. Jamaica Festival Queen, Jamaica Gospel Star, Jamaica Festival Song, Independence.